Good morning. My name is Dr. Emma Laurie, and I'm an associate professor at the Law School, University of Southampton. I'd like to talk to you in this brief presentation about the whole body of law that regulates the relationship between a landlord and a tenant, where the tenant is renting the property as their home. So not a commercial lease, but a residential lease. And so to introduce these ideas, I'd like to kind of put to you the proposition that I think most people would generally agree that having somewhere to live, somewhere to call home, is fundamental to your sense of well-being. But what does that mean if we translate it into law? What does it mean in law to have a home? And that's what I'd like to investigate in this short presentation. So you're studying land law, so I'm sure you already know that the requirements for a lease to exist were determined in the famous case Street and Mountford. And we go beyond that, though, with these deliberate parliamentary statutory interventions. So they take as their starting point the fact that the tenant has a tenancy. So Street and Mountford is relevant to establishing there is a tenancy, not just a license, but then superimposed over those requirements are these statutes that have been created at particular moments in time to give tenants usually more rights than they would get simply from the common law or, by contract. So I've identified three of the most important: the Rent Act 1977, the Housing Act 1988, and the Housing Act 1985. So the latter, the Housing Act 1985, deals with public sector landlords and tenants. So we're going to leave that aside, and I'm going to briefly talk to you about the Rent Act 1977 and the Housing Act 1988, because they are the ones that govern the private residential sector. So we could start by saying, well, why do we need these statutes? Well, we come back to this central point, and Lord Bingham, in this important case, the first case in this country where the Human Rights Act was used to challenge a repossession claim by the council, the landlord council, Harrow. And he said, few things are more central to the enjoyment of human life than having somewhere to live. So that, coming back to that fundamental principle that home is special, it's important, it's not just property, it has a meaning beyond a simple property right. And then typically, the reason Parliament has intervened is a power imbalance between landlord and tenant. Usually it's where there is a shortage of available homes. That clearly puts the landlord in a much stronger bargaining position. It would therefore allow the landlord to have the contract very much in their own favour, and if the tenant were sufficiently desperate for somewhere to live, they'd agree to anything. And there's a recognition historically that that's been the case in this country. And that is why Parliament has intervened. And I've just put very briefly the rent strikes during World War One, where landlords responded to increased demand by putting rents up and putting rents up. There were no controls on rents, how much they could charge, and so there was a civil unrest, which of course during World War One you really don't want any kind of civil unrest. But the really kind of interesting thing about this area of the law, or what I find interesting about this area of the law, is that it's very fluid because it reacts to the conditions of the time, if they're so socio-political, economic conditions. So if we look at the Rent Act 1977, it was very, very pro-tenant. So an extremely high degree of security of tenure for the tenant and a form of rent control. It was statutorily referred to as a fair rent, but the main point is that it kept rents below what the market would have permitted. But then we see a complete change around under the Housing Act 1988, which becomes very pro-landlord. So in contrast to the very high security of tenure that was present under the Rent Act, we now have a regime which is very pro-landlord. The Section 21, Housing Act 1988, Section 21, the so-called no-fault eviction, allows the landlord simply to end the tenancy by giving notice. In other words, the landlord doesn't have to prove in any way that the tenant has been at fault. It's simply the contractually agreed period has ended and the landlord chooses to end the tenancy. Now, there's nothing like that in the Rent Act 1977. So that was a complete change. And I should mention, you may well know, because you're renting under these types of tenancies, the assured short hold tenancy under the Housing Act 1988 is the current legislation. So very pro-landlord in terms of ability to gain repossession, and no rent control. So out goes the rent control from the Rent Act, and it is now simply a market rent. In other words, the normal reaction of a market to supply versus demand. Well, that was brought in under Margaret Thatcher's leadership, and it has prevailed since then. And that's despite the fact that social and economic conditions have changed quite substantially. So when it was introduced, the typical assured short hold tenant was seen as people who weren't yet ready to buy their own home. So they were people like you, like students or young professionals, people who didn't want owner occupation yet. They wanted to be geographically mobile, and then with the idea that at a later stage in their life they would buy, they would become owner occupiers. but that hasn't proved to be the case in recent years. As you may well know, house prices have risen so much that there is now a section of society who would like to buy but simply can't afford it. And so they are now living in the private rented sector much longer than was ever anticipated. But they still only have this very minimal security. So let's just sort of think about the most recent developments, bring us right up to date. The government last year, there was a consultation paper, and the government responded by saying that they were going to abolish the Section 21 notice only ground of repossession. Well, nothing has happened on that front. Okay, to be fair, we have had the COVID-19 pandemic, so they have been a little distracted, but they have had to, I say had to, they have brought in emergency legislation under the Coronavirus Act 2020, which put a temporary ban on landlords evicting tenants. Now, that temporary ban was extended, but is now ended. So we are anticipating a rush in the courts for landlords who have been waiting to be able to evict tenants, and you know, for good reasons. They're not all dreadful people. They quite reasonably want to regain their property, but just we need to think about what the consequences of that is going to be. If we have a lot of tenants being evicted from their private sector tenancy, we've got to ask, well, where are they going to go? If they can't afford another tenancy, perhaps they've been made redundant or furloughed. They may end up applying to the local authority under the homelessness provisions, which of course is going to create knock-on difficulties for local authorities who are already very financially stretched in trying to deal with homeless applications. Anyway, I simply wanted to give you a snapshot of an area of law that I find absolutely fascinating. I've devoted my entire academic career to it, and I wanted to give you a sense of it, and I hope to interest you in this area of the law.